And we're calling today's meeting to order. This is Board of Ethics, July 13th, 2017. It is 12 o'clock. We're starting a little late today. Roll call.
Ted Carlson.
Here.
Terry Kelly.
Here.
David Nesbitt.
Here.
Becky Wint is excused. Also present is Dee Ennis, Deputy Municipal Attorney, and Lisa Slusner, Deputy Municipal Clerk. You have a quorum.
Okay, very good. Do we have approval of the agenda? Keeping in mind that 7B is a time-sensitive item, and we'll move to 7B when the relevant party comes in.
Move to approve.
All right. Hearing no objections, the agenda is approved. Everyone take a look at the minutes from our May 10th meeting. We have a second?
Second.
Are there any objections or requests for additions or edits?
None from here.
All right, hearing no objections or additions, we'll take the minutes as approved. Let's take a look at 5, our consent agenda. And this is, so this is, we're taking a look at the forms, right, Lisa? So let's take a look at the forms. I think those are loose, right? Are those?
They're beginning with the green tab.
Beginning with the green
We'll give
tab.
disclosures first.
So taking a look at the ones under the green tab, these are gifts received. Anyone just kind of call out anyone that they,
Well, the first one is over the amount. but
Right.
She's the school secretary. And she has disclosed it.
Mhm.
So the ethics board still would weigh in on whether this is inconsistent, I think, with the underlying gift policies. I don't see that it is, but
yeah, I don't perceive much of a downstream effect here. What do you guys think?
Well, reading them, it doesn't say whether or not,
Right, I mean, there's
whether
no,
or not the students teach them.
it just
What
says
it
ASD
says,
employee.
it's a $50 limit, period.
Yeah. I mean, do we want to make exceptions for those who don't have students?
we do have a reservation for exceptions that can come before the board. I mean, we do have that, I think.
We have that catch-all.
Catch-all. Let me double check that, but I'm pretty sure.
I mean, we have exempted, like, for instance, teachers who get the gift after the student has graduated.
That we've made exceptions
And
like that. in the
we've
past,
said,
haven't we?
look, there's no downstream effect here for this particular case. I think we also made an exception maybe for someone who was a tutor, right, that wasn't involved in the student's grade or anything like that.
Because
So
I
the
have no
question would-
problem doing it.
Yeah,
I
the
just
question-
want to make sure we're okay.
Can I say, we do have a reservation for exceptions, F, in the
Okay.
gift. Board of Municipal Ethics Officer may review and approve a gift which is consistent with the public policy
Okay.
concerns.
All right, and we've done that in the past. I'm comfortable doing that here.
Okay.
Oh, Ted.
Okay, how about you? Are you-
Did
are
I
you-
interrupt you? I didn't
No,
know.
no.
Are you okay with that?
Yeah,
Okay. all right.
yeah, but,
But that's a good point, that
Yeah.
make sure that we have a reservation.
One time, so let's take a look at the next one. One-time gift $250 that can cut off. Something thanking me for supervising an intern first semester speech.
Lisa, this is one of the ones that I wonder if we should have more space for people to write in, although we haven't had this problem too often, in terms
The
of.
description.
Yeah.
Supervising an intern for the internship. Oh, I think I
So
see. Okay.
So it's from the intern, right?
It's from. No, I think she's supervisor. I get this is what maybe a teacher who
From
is
Idaho
supervising
State
an
University.
internship for an Idaho State University student, maybe, and then the the faculty member in charge of the internship maybe sent her a gift card
Yeah.
or some sort of gift thanking her for doing that supervision.
Thanking me for supervising an intern.
Yeah, so my guess would be that Robin
Mhm.
Ament is an education faculty member at Idaho State University, had a
Mhm.
student
Mhm.
who wanted to do an internship,
Mhm.
and maybe it's from Alaska and wanted to do it
And gave Heidi-
here. Heidi wound up supervising that intern,
Mhm.
and at the end of the internship,
So she's not an ASD employee.
well, Heidi probably is, but Robin's
Well, Heidi
not.
is, but
Yeah,
Robin's not.
Robin's not, and the intern probably was not as well. So again, this is another one I don't
Right.
see a downstream effect here.
Yeah, I'm okay with this also. Ted? I didn't mean to call on you. Since there are three of us.
You know, we wrote that up so we wouldn't have these.
I know. But we're not getting very many.
Well, that's the thing. Yeah, it's only a couple that every now and then the ones that fall into.
But, you know, what's going to be the effect downstream from this?
Well, I guess I wonder about. It is true the precedent that. Yeah, I don't.
Are we setting a precedent by doing this?
I assume that. I mean, this is where I don't have the background. Like, I assume ASD would have approved of this if this intern was doing if their student was doing their internship.
Oh, sure.
In an ASD
Go
classroom.
through
I
the process,
assume
sure.
ASD was sort of on board with this and had already approved
Yeah, in
that.
fact, it would have been done pursuant to a contract.
Yeah, right. And so,
You know,
so
and-
in that sense, I mean, I don't see. I mean, like, even if Heidi wound up taking part in what grade this intern got, that intern is not an ASD student. Is not. It's.
Well, Ted, can I say, to answer your point, I think there's always exceptions to the rules, and then we provided for that here, and we provided for it because I think I put it in there. Because there's always something that doesn't quite fit.
Right, but
And-
if you want to, send him a letter indicating that, we will approve this one here, but keep in mind, the statute of $50 limit, keep in mind, so that they know.
Well, for example, the next one is from the same teacher, right?
Oh, is it?
And it has to do with a $100 REI gift card.
Yeah.
Now, this may be different because it was a congratulatory gift and thank you, and this teacher was their son's SLP, special SLP. What is that?
Something special.
Special. Is that like special education?
Something, yeah, special education. I just don't know
Mhm.
what it sounds
That was their son's at the time and transitioning to a new position with the administration. For approximately 3.5 years, received a new position. So was she moving to a different position, and the family gave her a gift card because as like a thank you for the last 3.5 years? That's. Now this may be a different situation where we may want to send a letter.
So if whether it is an after the fact gift,
Mm-hmm.
whether she's really,
Mm-hmm. Yeah, I mean, I don't know.
Well, and I'll just say, these forms are structured as requests, so
Mhm.
whether you say yes or no, they get a letter.
Right.
And the letter includes all of the cautionary language that Ted is talking about.
because to me, if this was after the fact,
It sounds like it, doesn't it?
there wouldn't be a
Did you have any
downside.
contact with her? You don't
No.
know? No.
Yeah, so she got the new position. She received the new position in February. Was transitioning out, and then I originally submitted this gift to Columbia Fax in March. So yeah, so I guess she's got the new position, and she's just probably tying up loose ends with the
That's what it
SLP
sounds like.
stuff, and she gets a gift. from the student, you know.
I originally submitted this in March. Yeah.
We never got it. The fax machine was down at the election center, and so I remember she did email and say, I submitted this before, did you get it? And we went and checked, and we said, no, we never got it.
I mean, so this one, I mean, like, I can certainly see a version of events in which this is not problematic, right? But I can see a version of events where maybe it is. I mean, like, when she gets the gift, is she still issuing grades for this student? Is she even involved in issuing grades? Or is this, you know, is she, you know, just like is this a tutor type situation? If she's sort of like the special education provider, is that just tutoring and mentorship, or is there grade, you know, and I guess part of it too is also what's her administrative position. If it's principal of the school that kid's at, then that's actually a problem, right?
Right. Yeah. It doesn't sound like there's a continuing supervisory role here, but I don't know.
It
It's
doesn't,
hard-
no, it certainly doesn't sound like the worry we've always had is sort of like the teacher getting $100 from a student weeks before grades are due. That's the sort of textbook worry.
And I understand Ted's concern, like what happened to our bright line rule? Like we're just walking around it. On the other hand, these are the only ones we're getting anymore.
Right.
That's right. We've got
That's the-
there's
yeah.
a couple, right? And
Yeah.
they truly are. I would say they're authentically gray area
Right.
case where it's like,
Which is
oh,
kind of
yeah,
good.
yeah,
I mean, it's
think-
almost like we've. It's true, we're making exceptions for these, but these are the only ones we're getting because we have the bright line rule.
And we've
In a
already
way,
had the end of
right?
the year. This typically would have been
Oh,
3
you're right.
and
It
200.
That's right.
You're
That we
right.
got.
You're right.
That's what I'm saying.
Yeah,
So
that's a good point.
So I think that in some ways, the ones that we do get now probably are in the gray area more often than not, which I'm okay with.
Which is why we're here.
Which
right?
is why
You know,
we're here. Like
yeah.
I'm okay with this.
That's why we get sandwiches and candy.
This is
You know,
why
it's
we
just-
get water and Coke Zero.
Yeah, that's right. Okay,
I'm
so
okay
I'm
with
okay
it.
with this one too.
Yeah.
All right, let's move. Ted, are you?
Yeah,
you-
but like I say, you know, I just want to make sure that, another thing, these didn't go through the principal. You know, where they're supposed to either approve or not approve.
Are they? Really?
And then the
I think this is our
Get
approval.
referred to the,
I think, isn't this form, excuse me, Ted, isn't this form that, like, if I as an ethics officer approve or don't approve, or I say, no, I want it to go to the ethics
no,
board?
that,
Isn't
Yeah,
that-
I thought that was you. Approved, not approved.
Well, if it
Yeah.
went to the ethics officer level.
Right.
Right.
I was under the impression it was to go through the principal.
Well, we that was part of the for anonymity. That word. See anonymity.
Yeah, I would have that one.
You know the one where we through a group or through the principal or so they don't know who's getting it.
That was just a different
Yeah.
type of gift, and
Yeah.
that's not this.
Right. Those were the ones
So,
that.
do we sign these? The ones that come to us, referred to the Board of Ethics for review?
Well, I
One
sign
of
them
us-
on your behalf once you make your decision.
Oh, you do?
Yeah.
Oh, okay, good.
Wow,
All
look at
right.
that.
There we
Put
go.
approved or
Yeah.
not approved, and then sign
Okay.
it. And
Well,
send
good.
it back
See, I think
along
that-
with the letter saying it's been
Yeah.
your exception has been approved.
Oh, okay.
That has all the
There
cautionary
you go. I like
information
it.
in
I'll
it.
take that.
Yeah, I'm in.
Okay. All right.
All right, very good. Well, let's take a
We're
look
doing a
at.
great job, aren't we?
Okay, so.
I CC the principal.
right.
You do?
Yes.
Oh,
Yeah,
see, that's
okay.
great.
See how efficient we are when
That's
Becky's
great.
not here?
Yeah, I know.
Just kidding, Becky. All right, let's take a look at gifts for elected officials.
Kathleen Plunkett.
Should have a school board.
She's
This
on
is
board.
the first
Yeah.
use of our new form.
Oh. Mm.
She was ASD's representative to the state school board meeting.
Mhm.
Mhm.
Yeah.
List of that. Oh, okay. Well, this seems purpose, description of
Who paid for
gift.
it?
Yeah, who gave? Oh, name of gift
Sponsor.
sponsor was the Association of Alaska School Boards.
Oh.
Okay. And here's,
Well, that.
and our new rule is, an elected official may receive sponsor-provided registration fees, travel expenses, accommodation, meals, for an event related to official government business, education, or information gathering. If it's over 500, they have to file this form.
I didn't even know there was an association of Alaska school boards. Huh. Well, this would certainly seem to fall
Under
under
that.
Yeah,
Yeah,
this,
she's
this
just
looks
doing
this
it.
looks legit. Yeah.
She's just doing it.
Yeah.
I mean, this is a perfect example of,
Yes,
Yeah.
of the
yeah.
disclosure.
Yeah, right.
And I published it yesterday.
Yeah, no, I think that's good.
Okay, let's move on then to the conflict of interest forms.
The first one is Dina Bishop's.
Right.
Did you get more information on that?
Actually,
or-
I've been trying to call, but they're all in negotiations right now. But if you will look at there's one part of her, and when I say that, one thing I have discovered in the last couple days is that the ASD purchasing department really takes this stuff very seriously.
Mm.
And one of the ones that we've passed on in the past, and I don't want to use his name yet, they said no. They have since revoked it and said, no, we
Okay.
see a conflict.
Okay.
And so he was maybe going to come today, but I called them up again, in and out of negotiations. And I said, it seems to me that you have your right to impose supplemental rules. So, because probably in our world, it would have been managing the conflict. In their world, you're in violation of the school policy. So it was very interesting.
So this is not a rubber stamp kind of, what you're saying
No,
is David,
they are
David
really
Whiting
looking at
is
it.
really
Right.
careful to,
But
okay.
with this, with Bishop, she is the superintendent. There's that one. But there was something on her form that I thought was very helpful. And her husband is the vice president of ACS. I guess this is their policy. I thought that she had signed on to it. If you look on the back of the first page,
Oh, yeah, right.
is that the ASD policy is they have to disqualify number 2, B2, from participating in any decision. And so actually I thought that she had signed that and she hasn't. So maybe it's just a matter of confirming that for the time being. I don't want to keep jumping on other topics, but that she acknowledges that she won't be involved in the decision, that she'll follow the school policy. In fact, it doesn't say that. I have read and understand the provisions of this board policy. Okay, there. So she has signed it. She understands it.
What is ED? Is that education doctorate?
Where's
D,
your
I'm looking at her signature.
Oh.
D Bishop ED,
Oh yeah, Doctor of Education.
Doctor of Education.
So anyway, she is certifying that she'll abide by the school policy, which will be that she can't participate in any decision in the district to recommend an award to ACS.
Okay.
Now, if that is okay with the board, I, however, would like to invite David Whiting and other person's name, I think is Jim Graham, to a board meeting sometime to explain their process.
That'd be great.
Because
Yeah,
we
yeah.
absolutely do rely on their signature
Yeah,
when they
we
say
do.
no conflict.
Yeah.
And it sounds to me like they're far less formal. Like we have a independent purchasing department that they do most things much more informally per school.
Okay.
And that, so it would be sort of interesting.
That would be
15,
because you're
20
right.
minutes.
Yeah, we absolutely rely on
Yeah.
We do.
their judgment. We do.
And it may be that they're filtering already.
Yeah,
so if
I
they're,
think they are.
So the ones that we do see, it's not just that they're signing off on all of them.
Mhm.
We're just not seeing the ones that
They've already rejected.
Right.
right, which would be very valuable information for us
Yeah.
to know.
And this is just one that came in today,
thank you.
so just include it so I can not keep it on my desk for a month.
Yeah, it sounds like they're doing a very good job now and sort of looking at these type of things.
Okay. I appreciate that. Oh, we have Donaldson also. Okay. Was that TF? Teaching.
TA.
Oh, TA.
Yeah, teaching
Okay.
assistant, special education teaching
Gotcha.
assistant.
Okay.
Okay, but what's the business here? What's the?
Yeah, the business.
I guess
is-
And he's teaching an academy class for it. So he does some, the retired father still does some work for ASD, and she's a teaching
That's just
assistant.
teaching. Okay, yeah, that's
Yeah, that's pretty.
that's pretty.
tangential.
Okay.
Okay.
For present economic interest, there are no new disclosures, but I put the letter, when you tell me send them a letter, I thought you might want to see the letter that gets sent out because it's changed. I think you started, Glenda Regnart had an input in it, and then I think you took another pass at it, and then I've updated it with new code. But there's always this thing about what is that letter we send out?
Right.
So this is the letter that gets sent out.
Okay.
And the one behind it is the one that's got sent out to the chair
Okay.
of those, the planning and zoning, urban, all of those planning boards. Just in case there's something you want to modify or, and all the changes that's not exactly.
Can I make it one comment?
Mhm.
On the one to the chair, instead of is in a situation, tie it back to maybe when an individual has a financial or private interest that would lead, because the standard is financial or private interest versus in a situation. Or do both. When a person has a financial or private interest or is in a situation that would lead if you want the situation as a broader catch-all. But and the reason I sort of note this is because of conflict of interest. I'm not sure it really is that someone else would question the impartiality of their judgment. I'm not sure that's really the standard. Or perhaps it is to a lay person question.
That's Eric.
But anyway, to bring this back to, it's really them holding a financial or private interest. Versus
Should we-
in a situation.
Right. Should we get back to
Yeah.
this? Why don't we get Eric has arrived, so
Yeah.
why don't we?
Hey, I apologize. I had a
It's okay.
thing from about 10 to 1, but told him I could stay till noon and then jetted over here.
Oh, no worries.
7B.
7B, everyone. Eric, we first wanted to ask you if you were requesting an advisory opinion on this matter, and if you wanted to be confidential. We're okay. We had a little bit of discussion where we have no problem having an informal discussion with you on this matter, but we would have to be on the record then. We wouldn't have a sort of reason or justification to move to executive session to discuss the matter then.
Oh, I nothing really to hide on it. I wanted your guidance, I guess, whether that's discussion or any variety of advisory opinion. I'm open to yours. I just was doing what I thought was right and wanted to know whether it was or not, and if not, how to do it better next time.
Okay.
So what would you guys prefer? How do you like to handle that?
Well, I would prefer, one thought might be to have it be an advisory opinion so that we get something out that's out there for other assembly members to look at and future assembly members to be able to reference. If we did it as a confidential one, not that you have anything to hide, but we scrub it so that's just generic, so it wouldn't be clear, who we could even set it up. I think so it wouldn't even necessarily be clear that it was. I guess it would have to be an assembly because it's an elected.
Well, you would
we could
say
say
an
elected
assembly,
official.
or an
Like-
assembly member did something.
Oh, if it's scrubbing me, no, I don't want or ask for that. I haven't asked Mr. Kim, but I don't think there's anything really confidential that we discussed. All the things that I submitted were matters of public record, so
Yeah.
I guess I prefer public unless there's a significant reason to go private.
Okay. Well, yeah, I don't think there's a significant reason. Just
Well, that's entirely your
Yeah,
preference.
that's
So,
your
and
prerogative
my
for sure,
preference is
yeah.
towards public. Yeah.
And I guess I guess for about Mr. Kim, what do we think about that? Is that would that be a violation of confidentiality on Mr. Kim's part?
No, because
We
it's all
filed a
public.
public appeal. It
Public
was
appeal.
publicly decided.
For the BOE.
The only real document is the document of when they sent out those notices. That's publicly available. So I guess I don't see how there would be much of a
In
complaint.
any of the emails that you sent, I assume you're not going, none of that would be considered confidential communications between you and Mr. Kim.
Well, we could, Eric, you could look at 7B in that blue book over here and see what we have before us, because that's just the materials that
Yeah.
Lisa submitted. Go ahead and look at that. And that'll be easier too if the board has questions about the documents you have them right in front of you.
I'd say it's not really up to us. It's whatever relationship he has.
Right.
Well, and all of this is my communications with public tools summarizing his stuff. Do you even have in here, dear Mr. Kim from Eric, here's what I'm doing?
No, I don't think so. I didn't
No.
see one in there.
So I can't even, yeah, it is emails to the board members summarizing his thing, the letter back, the official, there's his warranty deed, but it was attached as part of my communication with government. That's the government.
And at
Yeah.
least the Department of Law is now taking a position that we often redact addresses and so whatever the opinion for we probably don't need to attach some of this stuff anyway, but we would be careful about things like that.
Yeah, that's a good point.
Phone
Don't
numbers
publish his
and addresses,
address,
yeah.
but otherwise, I think it's all public, or was attached as public. stuff.
Yeah, well, I don't even think we need to mention his name. We can be pretty
Yeah.
circumspect
Yeah,
about that
attach there.
anyway. That's right. Okay.
Help us keep track of that, Lisa.
Yes.
Well, in that case, Eric, do you want to just walk us through what happened here and what your
Yeah.
concerns were?
Well, I
Or
didn't have
not
any
were,
concerns.
or
right?
not were at first. And
I thought I was doing my job.
Uh-huh.
And so, in a training, Dee brought it up as an example of problematic conduct or what was brought up issues. And so that was the first, I thought of it as anything but exemplary public service. I do think in general that voting on things, debating, going to community council meetings, and making sure our constituents aren't lost in the bureaucracy is all appropriate assembly and legislative branch, if you will, duties. And so he had Mr. Kim approached me because in, I believe, February or March, he had asked to file a late appeal, and that had been denied. He wanted to know what he could do. The facts coming up, as I summarized in the ways that anyway, in the letters that I did, was this house had been on the market for some time at a very high price, $475. He had waited or negotiated, but when it finally had offered just $384, $500, and that's what it sold for. And that closed in December of 16. And he told me, he asked, what do I do about it, about the valuation, or how do I appeal the valuation? Because sometime in that process of being listed at $475, And my guess, but I don't know that, is the Muni was watching and seeing things advertised, and 475, they put it up to 475. It was a property that had been owned in a trust because the original owner had died, and so I don't know that there was anyone particularly to complain about that. And then he buys it. He says he was told by the real estate people to wait, get the green card, and then appeal. And he never got the green card, and so late, but within this sort of secondary late period, there's you're late and then you're irredeemably late almost. He comes in and says, he comes in, asks, they give him the form, and he appeals, and it gets rejected. And that's when he contacted me, and I go with him to the office and get this printout of when they sent the green card and what their record of transfer was. And that December 19th purchase was, the green cards go out January 13th, and on January 24, the MOA updates its records from the old trust for the person who'd been deceased to Mr. Kim. And so we think proved he'd never been sent a green card. Now, I'm sure the valuations people hear that all the time, and it seemed to me he was rejected as just another person who'd missed the deadline. And so I put at the beginning, and that had been my recollection from ethics briefings, I'm assisting him as elected representative under 11507B without compensation. So cited the reference. I did look at it before I did that. And then I described all that and asked how we could appeal. He eventually, they allowed it under reconsideration. They rejected him again, and I didn't get that communication. I hadn't entered as an attorney or anything. And by the time I figured it out, the time to appeal that to Superior Court had passed. So the result is not good constituent service in the extent that he still got that valuation, which I feel is way too high. And I don't know what I would have told him about what to do if we'd been in a timely way to Superior Court. I wasn't going to represent him as an attorney, and it's a difficult process to do on your own. Mr. Kim, in my experience, has some English. If you slow down, he can understand, but it is limited. And that created, I think, some of the confusion. His statement in his original appeal, I purchased house on December 16th, recording on December 21, title comp court told me that when received property tax card, go to Muni to appeals office. Since moved to house every day, I was waiting for card, but never seen. I stopped by Muni February 27th, so that'd be in that second period. Clerk, I think, told me to use this form to appeal. So that gets out actually the relevant facts, not fabulous English, but he described it correctly. And I continue to believe he got unfairly lost in the system. But when we're here, so that's just what it is now. But we're here. What I'd like to know is, what did I do anything wrong? What should I do in the future? How, in what ways should I help people that are in that situation? What's a poor assembly person to do?
Comments from board members?
Pretty clear in section B.
Which rule are you citing?
Easy for you to say. Yeah, so that's the way I read it, and then I think Dee can speak to how she thought it might have concerns and used it as a training tool, which is fine. That was no problem. But I read it and thought that's what I can do. I'm not charging the fee, never have, and so I thought that was authority to do that. I take it there's some concerns that I have such an august personage and influence over that I can sway the valuations or clerks people. Anyway, the Board of Valuation. Is it the Board?
Board of Equalization.
Right. Board of Equalization to my will. Clearly didn't, my august person didn't convince them to, in this case, but the general concern is still there, I guess.
Yeah, I mean, because it looks like 115.070 Big B has an inherent, I don't know if it's a conflict, but it has a competing subsection A2 little b,
Little big, right.
which is appear on behalf of a person at adjudicatory matter. And the concern there, of course, is that one is in more of a representation, advocacy type of a role versus an inquiry. And on behalf of an adjudicatory matter, and here the public and the what, the P&Z board, is that what we're talking
No,
about?
BOE.
The BOE
Organization.
is, that would be an adjudicatory matter before an appointed public body. And so I think it kind of comes down to whether this was less of an inquiry and more of a representation in front of the BOE. That would be my, that's
the concern I have. The
That's the
letter,
concern.
the undated letter we have from you to Monica Whedon. That's the second, right after your letter to
I don't know why I
us.
said Miss Monica, I was really looking at that information. But anyway, yeah.
It looks like it's a little bit of both. There's certain sections where it's clear you're asking for information, right? How can I serve my client or my
Right.
my constituent?
Yeah, careful.
Right. How can I serve my constituent to negotiate the bureaucracy? But a lot of the letter also looks like advocacy, right? It looks like you are advancing an argument for Mr. Kim, and then later in your April 5th email to her, you say, please consider, I assume this is the letter you're talking about, please consider that letter as a petition for reconsideration. So now you're actually filing a petition on behalf of, I'm just going to be honest, on behalf of your client, it seems to me,
Yeah.
right? This doesn't look like a public official helping a constituent gain information about the bureaucracy. This now looks like a public official who is now, for better or for worse, representing a constituent and filing things for the constituent. And it seems to me that's where there's concern. If there would be a concern, that's where the concern, where that is, that at a certain point in trying to gather information, look at the things that B talks about. Written inquiries, asking for explanations, asking for information. Notice that's all fairly passive type stuff. There's that line between, and it is a fine line and a gray line sometimes, between trying to secure information to help a constituent navigate a bureaucracy versus advocating, representing a constituent, filing petitions on behalf of a constituent. Notice at that point, when you're filing a petition for a constituent, it doesn't look like you're asking for information anymore. It looks like you're appearing on behalf of them.
You might add something too, and that is that simply by being an attorney, it's not your fault that you're an attorney to the extent
Kind
that,
of.
right, but what I mean is, there's a heightened level of scrutiny, you might say, to the extent that there is a representation that can easily occur, and as all attorneys know, that representation can occur very easily with very little representation on your part, and it has nothing to do with compensation. You can represent somebody pro bono, for example. So that would be a non-attorney member of the assembly might have a different level of concern, you might say. Whereas if this letter is coming from an attorney and it's coming from an assembly member, that has a different.
I had frankly read the Big B as,
Right.
as more keyed on the not charging for, and
Mhm.
more broadly than I see what you're talking about in terms of what it limits it to. So, what do you want me to do? I mean, Mr. Kim just doesn't get it, or gets parts of it. I mean, if I'd written all that up and said, file this yourself, is it really any better? Do I really say to somebody, again, who I think has been screwed through a misunderstanding into paying more property tax than they should and lives in my district, figure it out? Do I just, and if that's just really inquiries, why did you, while the time is ticking, why did you do this, which seems totally inappropriate? and yet it's not a petition they can act on?
Well, I mean, why couldn't, first of all, people represent themselves in these tax things all the time. So he could represent himself in that. Or if he felt it would be beneficial, he could certainly hire an attorney to represent him. And there's no obligation that you need to do that on his behalf. He has other means to accomplish the same goals, I would think. That would also not put you in a position of running potentially afoul of the code.
Well, yeah, so there's a question of running afoul of the code, and is that what we meant and really intend to have happen, and in terms of recommendations for future revisions of the code. But sticking to this as law as it is, I thought that to some extent was one of my jobs. Now, and do we really want, maybe that's bleeding into the other, do we really want to take that so far that that concern that somehow I might be more persuasive as an assembly member than your average bear, to the point of limiting the constituent service you can do? I mean, I do think this idea that they didn't seem to have, they're pretty robust, independent authorities. Is that as much of a concern to you guys that me saying, here's what the constituent said wrapped in a comprehensible package is a problem? I mean, really?
I have to look at this at a different angle. Would it make any difference if he was a carpenter rather than an attorney? Nothing that I read in there indicates that he's an attorney. So, I mean, just because you're an attorney shouldn't have any bearing on the case.
So your point is interesting. So when I said, okay, then we need it to be in petition. So I said, here's all the stuff. And they're like, we need it in this particular form. And I think the time had passed by then. So if it isn't considered that, so consider what I did before the petition, it's late again. I mean, because of these delays and who you asking and where does he go, all I think inquiries here. Now I've said, here's the deal. What do we do? Again, I think arguably much closer to an inquiry there. And by the time they come back and say, you file a petition within 30 days, it's passed. And so I say, well, consider the stuff I did explaining his situation to be the petition. Mm-hmm. If I don't do that, he's out again. Mm-hmm. So may not fit into there, but practically, I had to at that point either say, oh, thanks for the information, now he's blowing another deadline while we were talking about it, or consider the inquiries I made to be his actual petition for those reasons. And she also asked me, I think, it's these three areas. Again, I have no idea how to explain that, and frankly did not to Mr. Kim. I just said, we think it's a substantial procedural error and maybe kind of a misrepresentation if you want to fit it into those categories. But take what was done and put it into that box. Love, Eric.
Right. I mean, you might think of it, a couple of, one is the concern, of course, about influence. And even though Mr. Kim didn't prevail, that doesn't mean that you didn't even wind up having influence, right? It's hard to say, did the case wind up getting extra consideration? It looks to me like you brought Bill Falsey into this somehow. I'm not exactly sure that's something the normal citizen gets to do, is just call up Bill Falsey and ask for a legal opinion. So there's one, if you don't know, there's the concern about undue influence. And even though Mr. Kim didn't prevail, that doesn't mean that were not able to wind up using some of your political capital, symbolic capital, to have influence here. That's the concern area at the end. And then,
and if you did prevail, then what would that look like?
To other citizens, I mean, do you make it known to your constituents, and maybe you do you make it known to your constituents that generally you will represent them in these kinds of matters and file petitions for them? Or is it just the ones that happen to call you and that you happen to select and you happen to advocate for and file petitions? Is that your job? I mean, is your job as assembly person to be digging through people's equalization appeals and filing petitions on their behalf and calling Bill Falsey and getting information on it? Is that your job? And if that's your official job, then I think you need to make that known to your constituents generally, that that's what you do. That, oh, by the way, one of the things that I'll do as your elected officials, when you have an equalization problem, call me and I'll represent you.
Well, I don't know. No, of course not.
Right.
But I really felt like I was trying to get him heard by that group. I did not intend to appear in the valuation merits. Now, maybe that's a distinction that doesn't make any difference, but that he had been rejected over a confusion that they did not understand, and I was fighting for his right to appear, and I wasn't going to appear with him. I see what you mean with the consider this a thing. Sounds like an attorney filing a thing.
Right.
And,
Or just think with the language you just used.
You're fighting for
his
right.
right.
Yeah.
You're not,
Yeah,
you're,
right,
not,
right.
you're not inquiring, you're not seeking
Right.
information or an explanation. You were
Okay,
fighting
so-
for his right, and you can.
Last
Yeah.
week, somebody calls and says, I have complained to our permitting people that this property, is been a junk property and they're not doing anything. And I call and say, what the hell, here's the email, what the hell are you doing? That's nice from that, but
Yeah, it is, and that's
about
okay.
you're not, and more than just inquiries, I'll be then like, here's the thing that I've looked at it. Here's my picture of the house in Spinard. It's a trash heap. You should do something. I'm advocating that they do. Now, it's not before an adjudicatory body necessarily,
That's right.
but I am doing that all the time and
That's right.
should be. And here, again, I am trying to get him heard by an adjudicating body.
Mhm.
I am not appearing before. So, but over and over, I think most of my Spinard ones are before permitting. There are parks, advocacy. Why is this park not cleaned up? Because they live across from it. All right.
Well, because it seems that at some point you went from representative to representing in this particular case. But then, and maybe one of the clearer lines is adjudicatory. So so is Eric okay in a case, for instance, the Spinard, junk house, that because it's not before an adjudicatory board, that he can advocate on behalf of his constituents?
Well, you might think, that's not necessarily a private interest in that case, right? Like if it is in fact a junk house, then it's affecting the entire neighborhood, and it's part of the city's duty to be doing something about it. But in this particular case, in an adjudicatory, like Mr. Kim's case here, that's very clearly a private interest. It's one constituent's particular business with the city that you're getting.
Well, let's take that so it's a particular constituent that said, I can't sell my duplex because that's been trashy forever. And other people are pissed too, but I'm who's talking to you, and he's who I'm repeating, and I go and snap a picture and say, I don't live in the neighborhood, but he's mad, and so I'm mad. And that gets eventually, doesn't it, to we're ordering you to close down. We're ordering you to clean up. Is that I think that's adjudicatory. You are going to be ordered to take that car off your property or whatever. And at that point, can I say, here's these complaints, and I'm here too. I think this is trashy. I think it both on behalf of my constituent who thinks it's trashy, and I don't like it either. And I took pictures after he complained, and those are part of the record. And
See, Eric, I think you can set the wheels in motion on that type of an issue, but I'm not sure you should be at hearing that, any kind of adjudicatory hearing that has a decision with respect to that.
Because it's
matter.
before an appointed public body.
so when we get to that stage, I have to do what? I have
Observe.
laid.
I mean, that you set it in motion. You've got that hearing, right?
Which
Well,
is
wasn't I getting this hearing going on the other? All I wanted was him to have a valuation hearing that he would conduct. Wasn't I setting that in motion? Wasn't I trying to get him heard in a way that then I would not represent? So how you got to hear this? You administrative official, and I know that's not yet adjudicatory, but it has a adjudicatory end. you should do a complaint. You should proceed against them. I'm going to be mad if you don't. Like, I'm going to bug you if you don't proceed against them. When you and then when they proceed, I cannot say, well, let's separate it out. I took those pictures, he complained to me, I think this should be cleaned up, either as, I think he's right, or I'm a member of this neighborhood or general area, I think this is trash.
That you can do. There's an exception in the rule for you private. So let's assume not that.
All right. So I can fight for his right to be heard, but then I should stop at the place where it's an adjudicatory proceeding.
Because you're influencing a decision maker at that point, and your swag does matter then.
Because now this is before you're sending an email to the municipal attorney and to other people. That is influential. And that's more than setting something in motion and then stepping back and letting the process take place. Because what happened here, the process did take place. He was rejected a couple different times. I see a difference there. Maybe this needs to be perhaps amended to clarify that in some way. I don't know, but to me, I see a real difference.
What about, fighting to get that hearing held, but I'm not appearing at it? Again, that's what I thought I was doing here. I understand that. I did not intend to be there or submit anything on the appropriate valuation, both because I don't know it and because of this section. But I continue to, if the individual people responsible for filing a thing against the car and the junk property, right, don't do their job, I'm going to go up the line and pester them and say, Bill Falsey, I think this opens us up to liability as a nuisance and all those things. And then let's take the next step. If they're not hearing this, I want it heard. I will not appear when it's heard, but I want it heard. But you guys are saying that even, you should hear this on the merits, is inappropriate. This is why we're here, I want to know.
This is
but-
the junk house case now.
Well, but it applies to this. You should hear this on the merits.
Well, you're the lawyer. You know this one's different, right? he's already been rejected once, right? You're asking for reconsideration, so there's already an open adjudicatory matter here, which you're filing a petition for, which you yourself say is this is your petition for reconsideration, and you're asking
based on the merits.
Yeah, so legally, and I know morally that might not be the creed different, but legally there is already an adjudicatory process at work here, which you're participating in.
Appear on behalf of any person or any in an adjudicated manner. If I am trying to get, it's fine, but if I'm trying to get it heard, that is appearing, even if I have no intent on appearing once they agree to hear.
Once the adjudication begins.
Yeah, and I guess I just took apart, you got to hear my constituent and should, and how you decide I'm not going to participate in. But that it is part of my job to make sure they are heard. Mm-hmm. And he essentially was not. There was no even explanation for, we don't believe you, we don't, right? And so I did see it as part of saying, listen to them and I'm out. But you got to listen to them. And if you're not going to I'm going to push until you hear that. And then I'm not going to be around for whether the junk car is or is not a nuisance. But I'm going to be around to say you got to hear it and not reject it on technical grounds. Mm-hmm. And you guys are telling me that's wrong?
So appearing would be wrong. Do you see
Yeah.
that?
Yeah.
Okay,
and-
why would that be wrong?
The simple answer, because it's the code prohibits it. But
Okay.
So does that mean in person or in writing?
Like I said, I drew a distinction between them making a determination on the merits, which I am agnostic on, both because I'm not an expert at it and because it seems to me that's where the real danger is. You ought to take my constituent's house and value it at the purchase price of $384,500, and that's where their expertise is, and not hearing it at all, and maybe that's no difference at all, and you guys will tell me that is still adjudicatory when the adjudicatory body hasn't adjudicated anything yet, but has simply said they will not hear it. Isn't that fall on the other side of the line of what a representative should do? When the adjudicative body is doing its job and saying, on the merits, we believe that's a junk car, or the valuation is $400,000, I shouldn't be involved on behalf of other people.
Well, I guess you might say, I mean, like, part of an adjudicatory body's decisions might be in terms of, like, whether you filed on time or not, right? And it sounds like there's merits to that, and your initial letter seems to be advocating a lot of the merits for that adjudicatory decision,
That's right, that
You know, and so
preliminary-
that, you know, so again, that's how, at least technically, it's different, it seems to me, from the junk house case, that there has already been a decision made by this adjudicatory body. You want them to change their mind, so you're now entering this process, filing petitions on behalf of this constituent, asking them to reconsider the official decision that they've already made.
I
That at
see
least
how-
technically makes it really different from pestering the permitting people, say, hey, I think you should hold a hearing for this because this is in fact a junk house.
Getting them to hold a hearing where they've not been doing it, and then backing out of the hearing, versus getting them to have a valuation hearing when they've said they won't do that, is different because it has this timeliness and appeal, and by arguing that, I'm in it already. I mean,
For this case, yeah, technically, you know, the
I get that
adjudicatory
technicality.
processes are, I mean, this is sort of like, you know,
Well, I
it's
think
the
more
different.
than just technicality, though. I mean, to me, this is not just a semantic kind of discussion. I think this is substantive.
Well, right, I get it, but is the concern over the thing they're going to adjudicate or being heard? Like, is the concern that this addresses that I am affecting the merits of the adjudication? In the other, if they discretionarily decided they weren't going to, and I kept it up until they had a hearing and I did not participate, as opposed to a thing where you're already late, you know, one is like, just do it, and they're not doing it, and finally they do it, and I say, great, I'm done. Or, we think you're late. No, he wasn't late, and I understand how that's in,
A decision, right,
participation,
yeah, right.
but then get to the merits, and in the merits, I'm out. Does seem a technical distinction to me. I get that one requires a sort of entry, and I just say on the facts of this case, when I was summarizing for him that did not summarize his case very well, helped him find facts through inquiries that made it seem different, I think, than your run-of-the-mill, I looked for the card and didn't find it. And then by the time she said, it's got to be in Form 27B, right? It's got to be in done. The 30-ish days had passed.
Mhm.
You have to do it in this form with these three hoops to go through.
Mhm.
And what I said at that point, which I agree with you, is where it across the line is fine. Then consider that that backdate it to when we said all this, and we think it fits hoop number 1 and maybe 3.
Yeah, and again, I think you would have been, like in this particular case, I think you would have been okay if you had not done that.
The
And-
petition?
The petition,
Right.
and if your initial letter sort of like didn't have the meat of that middle paragraph.
merits,
You just
yeah.
sort of,
The
you just
merits
hadn't
stuff.
started arguing the merits of reconsideration.
Yeah, I mean,
That's,
it-
it seems,
yeah.
that there too, it seems to me like, again, if you look at B, you know, what are your verbal and written inquiries, requesting explanations or additional information? It seems in that middle paragraph there, you've gone beyond that, and you're now arguing as an
Well,
advocate.
you're attempting
for
to
it.
influence the outcome of an I'm struggling with this word because I'm focusing so much
Right.
on it. It's an attempt to alter the outcome based on that decision versus bring it to somebody's attention. That to me is different. And in your position as assembly member, if you want to change the rules somehow based on this, meaning there has to be, say for example, you want to change the rules and there has to be a written explanation of why, under certain circumstances, this petition upon review have been denied a second time or something like that, that would seem to me an effective use and perfectly within the role as assembly members to try to change the rules so that future potential litigants would have an easier time of it, or being brought before them, or however you want to say it. But to try to influence the outcome of this individual's petition based on your and as an assembly member trying to do that, that seems to me is substantive, not just a procedural or semantic type of difference.
Right.
Yet versus the
But-
junk heap, where you're trying to bring it to somebody's attention. This is a junk heap that's in my neighborhood. These are constituents that are reporting to me. This is a junk heap. This needs attention. Is different to me.
I guess, you know, the way I think about it, and this is why I see the force of what Eric is saying, is it, like in both cases, and this is why I talk about being a
Right.
technical difference. Like, in both cases, Eric might be, or an assembly person might be using their influence
Right.
as the assembly person
That's right.
to influence the decision of a city decision maker, right?
Sure.
Whether it's the, you know, something about the junk house, or in this case, whether it's the Board of Equalization, right? And generally, the worry I think there's two principled worries here. One, is it undue influence that the average citizen was like, wow, well, that seems like, wow, it's nice that Mr. So-and-so gets this assembly person weighing in on their behalf. Not every citizen gets that, so that's unfair. And then two is that the proper use of municipal resources. Is that the proper thing that assembly persons should be spending their time on when their job presumably is the common good of the city? Should they be spending their time representing some people for certain kinds of things? So, you know, so I see in both kind of cases, the assembly person is using their influence to change the outlook of a decision maker. At least for me, that's why I wonder if what's different about the two cases is the private interest versus the public interest. If it's a junk house in a neighborhood, then as the representative of that neighborhood, even if you don't live in it, if they're your constituents, as the representative of the neighborhood generally suffers from that. Now, it may be one individual citizen who's bringing the concern, but the
where do you start
concern.
drawing the line there? I mean, between private and public. I mean, how are you going to start drawing that line? Because how
Well,
does
I'm
this
not-
person not also represent a public concern, which is people who are either not being heard on their petitions? I mean, that to me could be
Yeah,
very
but-
easily
but-
considered. I know that this is a very private person, but how is that not also influential on?
No, because what's the interest at stake here is this person's equalization done. If Eric began using his time to rewrite the codes on this matter and the regulations to make it easier for people to violate it, I think that's the appropriate use of
Absolutely.
assembly
That's-
person's
no,
time. That's
no
public.
question.
Whether
No
you can
question.
draw the line in a clear, bright way, I'm not sure, but there are going to be some cases that are obviously a private interest,
Yeah.
like this equalization case. And in other cases, that would obviously be a public interest, rewriting the regulations so that people can file more easily, or getting rid of a junk house, or some
Sure,
sort
but-
of nuisance or danger in someone's neighborhood. It may be one citizen who files the complaint, but if you have a junk house that's being used as a crack house or
Yeah.
this or that, it seems to me that what's the overall concern? The blight, the safety issues, the law and orders. Those are all public issues. This issue
Well, the
is.
bright line that's here is adjudicatory body,
Yeah.
right? And
That's
that
right.
I-
That's right.
that I
That's right.
Got too far on. So we really, and this sort of questions the way it's written, and are we doing the right thing? Not so much you guys' application of these facts to that law, but are we really so much more afraid of an adjudicatory body? Like if I call John Rada and say, and the budget is up, like clean up this damn park, that is, I mean, that's, and to some extent, I think, I don't know, I think it gets a bad name, but it's how we have this electoral loop that makes bureaucracies respond to individual complaints they might ignore, right? And it's not perfect, but it is the loop of, I'm listening, and I've said to constituents, well, I know you've complained, sometimes it's a little different when I complain, let me see what happens. And you haven't removed that snow, and they think a fire truck can't get in, and the snow's removed, or sometimes it isn't. But
Sure.
so, or Rada wants to clean up the park because I've made a persuasive case, or because the budget is up next week,
Sure.
and aren't they more susceptible to that kind of you better freaking do it because now it's a big deal, than an adjudicatory body that serves
Mhm.
protected terms? Like, why have we? I get the sort of representing I'm here as an attorney, but are we really so worried about their autonomy that me saying, here's the petition, I'm not going to participate in the merits, but I think you ought to listen to it, is that big a worry for us as compared to like the things we do every day with mid-level bureaucrats who might be very concerned that a less guarded assembly person would really do things to threaten their job if they didn't shovel the snow at Miss
Sure.
Granny's house.
Yeah.
And so I guess the reason I didn't see this as so much of a danger is they're a freaking big boy and girl board. I did want them to hear the claim, the same way I want that snow pile removed and the park cleaned up. And what is the and it's such an important and a function, almost a safety check on the system that you can get lost in a bureaucracy and somebody can get, and then that mid-level bureaucrat has the choice of, now I'm ignoring Eric and Tim Steele, who both say, why hasn't this been cleaned up? And I can do that, but it gets a little riskier. And so why are we so worried about these guys?
Well, it could be in part because the adjudicatory processes, particularly, right, are supposed to be impartial. They're supposed to observe due process, and they're supposed to be fair, broadly.
Which
just
didn't
as-
happen here. I know that's the merits, not the thing, but I'm still.
Well, I mean,
a little-
again, it might be, for someone else who filed late and got rejected and didn't realize that they could have their assembly person weigh in, advocate, file petitions, call the city attorney and get an opinion or some view from the city attorney. Every other constituent of yours who doesn't realize that that's one of the services you provide as an assembly person has been jobbed.
No,
Right.
not any more than somebody who didn't get their street plowed and didn't decide to call me and say my street.
And I
get
didn't
plowed.
decide, didn't know, right? I think most citizens know that when the park's not clean, or when there's a junk house in your neighborhood, or the city's not getting plowed, you can call your assembly person. I think
And-
most people know that. I think it's not common knowledge among citizens that the service that you will provide is advocating for them on behalf of appeals that they're making towards tax evaluation of their house, or whatever else
I
they're in
didn't get
business,
my
whatever
green-
else your shingle is also going to represent them for. And that's unfair.
I didn't get my green card, and I don't know what to do about it. I do think while I'm on the list of, they just said valuation. I get valuation, mainly going door to door, but valuation when it's up is the big topic of the month. And so I think it is general. I am on the list of people they would call to say, what the heck just happened?
Oh, yes, for information, right? I think when people want the park clean, they know that they will call you, and it's part of your job to advocate for them. That's why you're there. Public good, clean the park up, right? Make the city safe, make the city clean. Whether people know that they can call you, whether they really should even expect that, right? That they can call their assembly person, and you're not just going to give me any information about my
I
ecosystem.
understand what
You're
you're
not going to
saying.
give me
Yeah,
the
yeah,
forms.
yeah.
You're actually
Yeah.
going to represent me.
Not on behalf of my neighborhood.
Not on behalf of my neighborhood, and not for an item that has anything to do with the common good or the
But for
public
me.
good or the public weal. It's for me,
For influence.
for influence. Now, I might want your influence to clean up the park,
Right.
but that's your job. This is your intuition here. That's your
For the
job.
city.
I elected you. I voted for you,
Yeah.
amongst other things, to keep my
Well, the
neighborhood
guy
clean.
who's
my
got
community.
the car in there doesn't think it is. Like, he thinks it's a personal dispute between the two of them, and I should butt out.
Yeah.
And that this is none of my business.
Right.
But I disagree. And making sure government agencies listen to and actually hear citizen complaints, I did believe and would still assert is part of my job. What they decide on the merits, I have less of a opinion or view or expertise on, and in some understand why I'm totally walled off of. But you didn't listen to my guy. Hear him and decide. Again, I totally get how that's participation in I would say a technical way. Get this petition heard. He gave me the information. Here it is. Hear it. And I'm not going to tell you what to decide on it.
I know,
But
but the
I am-
problem is they
Yeah,
already
but
have decided. They've
that's
already
right, they've
received
already-
his
that's right.
appeal. They've already rejected it.
Not
and
on the merits.
now you're coming in. Well,
On
well, they're
being
not
late.
rejecting on the merits of the equalization, but they are rejecting it on the grounds that it has failed the various deadlines. Right now, and that's a discretionary decision that they've made. Now you're coming in as the assembly person saying, I want you to revisit that decision and to change your mind. And I'm not going to let Mr. Kim do that, and I'm going to do that. I'm going to come in and I'm going to start sending you emails, and I'm
Yeah,
going to
change
forward
your
you.
mind.
I'm going to forward you emails from the city attorney,
Which is
and I'm going to
advocacy.
file petitions for this
Yeah.
person. So one, you are advocating,
Yeah.
and two, you're advocating. Say not on the merits can be really misleading. There's two different decisions.
That's right. They both have merit.
They both have merits,
both-
and you
right.
are involved in the merits with
Yeah.
the first decision.
Exactly right.
Is the appeal in fact late, and can it be considered as merit? That decision has merits one way or the other, and there is where you're waiting in
And
on
I
the
should-
merits.
I should not advocate for them to hear it on the actual merits rather than the procedural, if you will, merits, if you want to call it that.
Yeah, no. What I think the code lets you do is it lets you call and find I think even as much as call. Hey, I've got a constituent. What do they need to do? This person's confused. Maybe they're English limited proficiency. What do I need to do? Can I gather the forms? Can I do this? Can I do that? And then you can provide this. Here's what I found for you. Here are the forms. Here's what you need to do. And lay it all out, and make it as easy as possible for that constituent to get involved in the process. But it seems to me when you start
Write
emailing
up the
the
summary
board,
with him in my office, write up the summary, because he couldn't have done that, and then he walks it over there?
I think that would actually be it. That's up to you. It
So,
seems to
well,
me.
okay, so I see, he sits there, I write it all up, now you sign it and walk it over.
The one concern I would have is if you're doing that on municipal time, because then it seems to me that that's not your job.
See, I think
Okay,
it is
so
his
I
job. I do
Yeah,
think that
okay.
is
Yeah,
his job.
okay.
And then you don't want to get into a public purpose
Yeah,
or public good
yeah.
analysis.
So he said, here's what we found. I walked him over to the valuation office. I watched him ask them. They didn't understand. He didn't understand. He was about to get the wrong stuff. Can you give us just the printout for this location? He did. I don't think he still saw it, but you didn't get it until the 24th. When did the cards went out on the 13th, and they didn't change the valuation until the 24th. And then we go back and we write it all. I listen to him. We write it all out, and he signs it. And then in this interchange, I go back to him and I say, they have said it has to be some kind of procedural problem. No. So good luck with that. Or I think what it is substantial procedural error. It looks like to me, Mr. Kim. I know you may not know what that means, but it seems like it's substantial procedural error. It may be misrepresentation. You know how to say that? Or I've written a sentence that is, I think it's substantial procedural error, and I request that you hear this from when it was originally sent, and he signs that, and he walks it over. And that's the difference.
Well, in terms of the code, I think it would be. Yeah, I think there you'd be okay. Because
so I do
remember
all
part
the
of
same work, and he signs it.
because remember part of the purpose here is to prevent elected officials from having undue influence on what is supposed to be an impartial and objective adjudicatory procedure.
Yeah,
and so what you do, so when
right.
Mr. Kim sends a letter, what you don't get is the staff person for that commission going, "Oh my God, that's Eric Croft. Is
That's
he even
Eric
allowed to
Croft's
do
email.
that?" Or wow, what happens if we turn this person out? Well, we better take an even closer look at this case than those other cases. And so then that fuels
Do you
into
really think
the.
that
I think that is exactly. You.
What about when I appeal my home valuation to the
why would-
adjudicatory board? Do you think they can hear that on the merits? When I say my home is improperly valued, as I have the right to do, or do we think they short circuit when I appear in the room? I mean, I do think they can hear it and tell me yes or no, and we have a robust enough system that they're not going to cave when I walk in the room. Do you really think they would give me whatever valuation I wanted?
I would at least suspect it. Maybe not anyone that you wanted, but do you get within the gray areas? Do you get the benefit of the doubt because of your position? And I'll be perfectly honest. I think there's a ton of social psychology that shows that that's true. that people in positions of authority, when it comes to the fine gray area judgments, get the benefit of the doubt.
Now,
Well,
under the facts of this case, would Eric be able to go under this big B and and go to the board and say, I want more information as to why that was denied? Some explanation beyond what you did, which essentially is just rubber stamping it and saying, no, we're not going to hear this appeal.
Or isn't that an appeal
I think
of
you
the?
could.
Now that would be part. Say, hey, this was denied. My constituent doesn't understand what's happening or hasn't been able to figure out why this was changed. Based on this information, we need better information. We need more of an explanation from you as to why this was denied under these facts.
I
Now,
think
that's a request.
representing. I mean, that's the kind of things that.
But you're not trying to change the decision.
Oh, I'm not. I'm not
Well,
elevating. Tell
the-
me why you rejected this with no explanation. Okay. I mean, if I have that, that's a oh shit. We better look and see whether we had. And then there's a series of things Mr. Kim is filing that are written the way that is. Me hearing his thing, looking at the documents, writing it up for him, and Mr. Kim's signature solves that worry for you.
Not for me, but for the code it would.
Okay. Well, no.
Because my worries are broader, right? My worries are broad. My worries are that you're a public official, in essence, using your influence and your time for, in essence, what is a private matter, and your constituents don't generally know. And in fact, I doubt you're actually offering a general policy. I will represent you in these matters if you just shoot me an email or give me a call.
Oh, I think that's what I do all the time. So that's different than. But we've walled off this adjudicator body, and that's what puzzled me a little.
I'm sorry.
They got that.
I got to run up.
Yeah, thank
I'm
you.
sorry to leave.
Yeah.
I've enjoyed the
It's been
pre-board.
great.
This is a really good discussion, and I enjoy it. I do have to go.
And
For
I
my
hate to say it
clients.
that when David leaves, we lose our quorum. And
But I wanted to say, I would love to have Amy and Rebecca here. Rebecca does all the land use boards.
Bye.
Go ahead.
Eric, great, thank you. Yeah.
Good. Listen to the meeting too.